County Board of Elections will hold a regular meeting of the members on March 1st in the boardroom. The board will also hear protests filed by Attorney James Ballone and a reconsideration filed by Judge Dom Leon. Would the director call the roll, please?
Ms. Calpesta.
Present.
Attorney Beatrice.
Here.
Ms. Barger.
Here.
Mr. Arndt.
Here.
Would the director lead us in the Pledge of Allegiance, please? Assistant Director.
Somebody.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Can we have a moment of silence for our nation and our troops? And my son, who's, I don't know where. All right. We're going to have now a reorganization of the Board of Directors of the Mahoning County Board of Elections. We have to select a temporary chairperson. I nominate Sandra Barger as the temporary chairperson.
Second.
There's been a motion and a second. Is there any discussion? Would the director call the roll, please?
Ms. Calpesta.
Yes.
Attorney Beatrice.
Yes.
Ms. Barger.
Yes.
Mr. Arndt.
Yes.
Okay, now the next step in the reorganization is to appoint a director.
Bob.
I'd like to nominate Tom McCabe as the director.
Second.
Is there any discussion? Would the director call the, would Tom call the roll?
Ms. Calpesta.
Yes.
Attorney Beatrice.
Yes.
Ms. Barger.
Yes.
Mr. Arndt.
Yes.
And now we have to appoint a deputy director.
I nominate Melissa Wasco.
I'll second.
You want to call the roll? Is there, well, we had a second already.
Yeah, but no discussion.
No discussion?
Ms. Calpesta.
Yes.
Attorney Beatrice.
Yes.
Ms. Barger.
Yes.
Mr. Arndt.
Yes.
And now we have to appoint a chairman.
I would like to nominate David Beatrice as chairman.
Actually, somebody from the opposite party has to do that, so I will nominate Dave Beatrice.
Okay,
Is there a,
I
Do
second.
we have a second?
I'll second.
Call the roll, Tom.
Ms. Calpesta.
Yes.
Attorney Beatrice. Ms.
yeah, am I allowed to vote for myself? Yes.
Ms. Barger.
Yes.
Mr. Arndt.
Yes.
All right, so she'll pass the thing over to me. Now we'll do a selection of a vice chairman of the Mahoning County Board of Elections. And Joyce, do you have a motion?
I nominate Sandra Barger.
A motion to elect Sandra Barger as the vice chairman or vice chairperson of the Mahoning County Board of Elections. Is there a second?
I'll second.
There's a second. Is there any discussion? Hearing none, would the director call the roll?
Ms. Calpesta.
Yes.
Attorney Beatrice.
Yes.
Ms. Barger.
Yes.
Mr. Arndt.
Yes.
Now we'll have the appointment of the Mahoning County Board of Elections Republican and Democratic full-time staff. I'd entertain a motion, please.
So moved.
There's a motion by Joyce Calpesta to appoint the Mahoning County Board of Elections Republican and Democratic full-time staff. Is there a second?
I'll second.
There's a second by Sandra Barger. Is there any discussion? Hearing none, would the director call the roll?
Ms. Calpesta.
Yes.
Attorney Beatrice.
Yes.
Ms. Barger.
Yes.
Mr. Arndt.
Yes.
Would the, all of the full-time members and the director and deputy director get ready to take the oath, please? Can you all raise your right hand? I state your name.
I, Danielle O'Neill,
Do solemnly swear
do solemnly swear
that I will support the constitutions of the United States and state of Ohio,
That I will support the Constitution of the United States and the state of Ohio.
that I will enforce the election laws
That I will enforce the election laws
that I will protect, preserve the records and property pertaining to elections
That I will protect, preserve the records,
pertaining to elections, and perform my duties as member of the Board of Elections.
and perform my duties as a member of the Board of Elections.
This I do to the best of my ability.
This I do to the best of my ability.
This I shall do as I swear and answer unto God.
This I shall do as I swear and answer to God.
Congratulations, staff. They don't have to stay, you don't
You
have
don't
to
want
stay,
to, okay.
unless you want to. I will now entertain a motion to approve the minutes of the February 7th, 2023 regular board meeting and the February 21st, 2023 emergency board meeting.
So moved.
I'll second.
Is there any discussion? Hearing none, would the director call the roll?
Ms. Skelpesta.
Yes.
Attorney Beatrice.
Yes.
Ms. Barger.
Yes.
Now I'll entertain a motion to approve the bills of account and payments for August 22nd and January and February of 2023. I thought we already did this, but,
Do you have any?
No, these are new bills.
These are
Um,
new
Okay.
bills.
I'll
Okay.
get that way because
Yeah.
there's some straggling folder for
all right, is there a motion?
So moved.
Is there a second?
Second.
Is there any discussion? Hearing none? would the
Well,
dir-
wait a minute.
Oh,
I do want to mention that the election systems and software, which is for the
DSNS.
high-speed scanners, are $251,695.
That's a separate item on our thing.
Huh?
That's a separate.
Yeah, but that's the amount that's on here, approved. So are we gonna do that first, or?
You're talking
Well, that
about
was
two
already-
different ones.
Okay.
No, let me clarify for you because you have the right to ask me that. So the ones on here, are you looking on here? Those were the ones that you approved a while ago. We purchased two. And you had approved those a long time ago. The one we're gonna talk about today is a brand new one. Is that what you're referring to?
Okay, because it's the
Yep.
same number.
It is. It's
Okay.
exactly the same piece of equipment as
Okay.
well.
It's not as much, that was two. It's not as much, that was two pieces of equipment.
Right, but it's the same. It's a 950 ballot scanner.
Okay. Thank you.
All right, any other questions or comments? Hearing none, would the director call the roll?
Ms. Skelpesta.
Yes.
Attorney Beatrice.
Yes.
Ms. Barger.
Yes.
Mr. Arch.
Yes.
We're going to certify the validity and sufficiency of the local option petitions for the May 2nd, 2023 primary election.
So moved.
There's
I'll
a
second.
second. Is there any discussion? Didn't we already approve these, or is it?
Well, we had a
You never had a
motion and
motion and a vote.
so we didn't take a vote. The
Okay.
final.
All right, we didn't take a vote. Any other discussion? Hearing none, would the director call the roll?
Ms. Skelpesta.
Yes.
Attorney Beatrice.
Yes.
Ms. Barger.
Yes.
Mr. Arch.
Yes.
And now we need a motion for approval of the E ES&S DS950 scanner.
So do you want an explanation?
Yes.
Okay. So.
Well, let's get a motion and a second and then discussion.
Okay.
Is there a motion?
So moved.
There's a motion by Joyce Kelpesta. Is there a second?
I'll second.
Second by Sandy Barger. Now, any discussion? Go ahead, Melissa.
Okay, so that was part of the VEAP program, that, and if you look in your packet, you have a handout there that tells you what we received, $107,000. So we received $107,000, and we would receive monies back from the 850. So just like we did with the last two, we traded in.
Okay.
Essentially, though, this won't cost us anything because the trade-in value is the same value that we had to ask the commissioners for, which is about $17,000. So eventually, this will be essentially free. And your email, the email that you have there shows that, if you're interested in that.
Well, it's not free, I mean, we're using money that we had left over from the grant.
Well, we're using the grant money, it's
Yeah.
$107,000.
Nothing is free from ES&S.
And then 17, well, that comes from, that's from the state, and then the 17,000 from the commissioners, we're getting a buyback of about the same amount of money over the next 3 years. So it's
Any-
a good question about the cost, that's, yeah, and it's the same as the two 950s that we just got, and it'll replace the 850, and it's for the absentee ballot.
Any other discussion? There's a motion and a second. Would the director call the roll?
Ms. Skelpesta.
Yes.
Attorney Beatrice.
Yes.
Ms. Barger.
Yes.
Mr. Arch.
Yes.
All right, now we're going to hear the reconsideration of candidate Dom Leone and the protest hearing of attorney James Malone. And let me tell you how this is going to work. First, the board acts as a quasi-judicial body. We have a right to subpoena witnesses, and we did. We are going to call our witnesses. I'm going to have the witnesses identify some exhibits, and then the board members will have a right to ask questions, and then Lou will have a right to ask questions or cross-examine, and John will also have that. But before we begin, if either, the first thing we're going to do is the reconsideration of candidate Dom Leone. And we all met ahead of time and said that if either party wants to give an opening, they can, or they can waive. It's entirely up to you. Lou, did you want to start with anything?
Sure, I'll just say what I said at the last meeting, that we believe, based on our review of the petitions, that there are 46 valid signatures on those petitions. We took 4 affidavits at the February 7th meeting, which got us to 50. At that time, you had indicated there were 45, and again, last week you said there were 45. We stand by our position, there are 46. In addition, there were a number of other affidavits that have been submitted that would push us well beyond 50. So I think the only issue for his reconsideration is whether or not we have 50 valid signatures, and I believe we do. And if that threshold is met, I think it would then turn to Attorney Malone's protest. They've withdrawn their first issue, which is the Savco affidavit. And it would simply move on to that second issue about whether or not the second set of petitions is barred by law.
Okay. Thank you, John. Attorney Uhas.
That's okay. As it relates to the reconsideration only, because I assume you're going to separately later on address the challenge, correct?
We're going to do the reconsideration and then the protest.
Right, okay. So our concern, and what I would urge the board to do, is first take a vote among yourselves and decide what it is that you're going to hear, because you've already heard a protest. You've already, in essence, heard the reconsideration because you took evidence on February 7th. So I don't see anything specific in the statutes that talks about a reconsideration. That doesn't mean that there can't be a reconsideration. We get that. We see that there's some of that in the law. We're not suggesting you can't do it. What we are suggesting is that based upon what you've already done, before you proceed tonight, you should take a vote on what it is that you're going to hear, because it really should be limited. After all, I know what you've said about the idea of wide open suffrage. I don't think there's anybody that disagrees with that. But even in that light, there have to be some rules. I can't just walk into this board and say, the next time you guys have an election for county commissioner, go ahead and put me on the ballot. And I walk out. My name's Uhas, and I walk out. So there have to be some requirements. They are minimal, but they have to be met. And when it comes to whether the board is following the law, that's where we start to look at abuse of discretion. As you know, there are 2 avenues of possible review if we go beyond tonight. One's abuse of discretion, one's fraud and corruption. We're not making any allegation of the latter. But what I'm suggesting to you is that because you have already heard evidence, it's possibly an equal protection violation, because how many times does a candidate get to come and say, let me fix my petitions?
Twice.
I hear what you're saying, Mr. Uhas. We have subpoenaed our own witnesses, and I think once you hear from these witnesses, it'll address a lot of the concerns you have. So at this point, if there's anyone that's going to testify other than the people that are here, meaning Jim Malone or Judge Dom Leone, I'd ask that you separate now. So is there anyone that's going to testify at either one of these hearings?
You're subpoenaed. You,
Is he, Mr. Safko, in the room? Mr. Safko, if you could excuse yourself, and we'll call you at the appropriate time.
Okay.
And Mr. DeLoss will call you at the appropriate time.
hey, Dominic.
So the board would call as its first witness Mahoney County Sheriff Deputy John, is it Catch? T. Catch. Could you be sworn in, please? She's going to swear in.
You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
This is being taken down by a court reporter, so we need you to state your name for the record.
Deputy John T. Catch, T-K-A-C-H.
And Mr. T. Catch, my name is David Beatrice. I'm the chairman of the Mahoney County Board of Elections. Sitting to my immediate left is board member Joyce Kale Pesta. Seated to my immediate right is the vice chair of the Board of Elections, Sandra Barger. And seated to her right and my far right is Bob Arnott, and also a board member. We have a couple of questions that we'd like to ask you. We asked you to serve some subpoenas, is that correct?
Correct.
All right. And showing you what's been marked as Exhibit 4, and I'll let John and Lou look at this before I show it to them. I'm handing the witness what's been previously marked as Board Exhibit 4, and I'm going to ask, first of all, where do you work, sir?
Mahoney County Sheriff's Office,
And how long have you worked there?
26 years.
And did you serve some subpoenas at the board's request?
Yes.
Do you know who the two witnesses are you subpoenaed? Is there a document I could show you that will refresh your recollection?
Yes.
Handing you what's been marked for identification purposes is Board's Exhibit 4. Do you recognize that?
Yes.
What is that?
The document I had Richard Safko sign.
And is that one person we asked you to subpoena?
Yes.
And did you subpoena him?
Yes.
Did you physically give it to him?
Yes.
Okay. And is there anyone else we had you subpoena?
The lost.
Okay. And John and Lou,
It's the same?
Yeah.
I'm good.
handing you what's been marked previously as Board's Exhibit 7. I'm going to ask if you recognize that.
Yes.
And is that a subpoena that you served?
Yes.
Did you serve that subpoena in the regular course of your employment?
Yes.
Okay. Does the board have any questions of this witness?
No question. I'm Joyce Gilpin, I have a question. Did you physically watch each person sign that affidavit?
Yes, I did.
And on Exhibit, go ahead, Sandy, any questions? On Exhibit 4 and on Exhibit 7, there are two different signatures. You saw both Ray DeLost and Mr. Safko sign for both of those?
Correct.
In your presence?
Yes.
Okay, any other questions?
Nope.
All right, we will call now Mr. Richard Safko, please.
Thank you. Thank you, Don.
Mr. Tafko, we're going to have you sworn in here, please.
Okay. Right here.
Yeah, she swear you in.
Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You can have a seat.
Thank you.
everything you're saying is being taken down by a court reporter. We'd ask that you audibilize every answer. In the normal course of human conversations, we use nonverbal cues to one another. We can't have that here, so everything has to be audibilized. No shaking of the heads or shrugging of the shoulders, okay?
Yes.
Okay, very good. Could you state your name, please?
Richard Edward Safco Jr.
And Mr. Safco, where do you currently reside?
512 8th Street, Struthers, Ohio.
Okay. Now, I have a number of exhibits I'm going to ask you about, and I want you to tell me about these exhibits, okay? The first is Board Exhibit 1. It is an application for an absentee voter ballot. Would John or Lou like to look at this, please?
I'm gonna go sit here.
Yeah, I would just pull some seats up.
Oh, here, I'm sorry. I'm just gonna pull this one, John can sit there.
Mr. Safco, this was signed in March.
Wait, hold on a second. I'm handing you what's been marked for identification purposes as Board's Exhibit 1. Board's Exhibit 1 is an absolute, let me get through them and then we can ask. Is an application for an absentee voter ballot dated 5/5 of 15. Could you hand that to the witness, please? Is that, Mr. Safco, is that your signature?
Yes, it is.
And did you sign that?
Yes, I did.
Okay, you can hand it back. Just turn it over, put it right there. Exhibit number 2 is a board exhibit. It is a signed voter registration form. It looks like it's dated 5/15, 5/5 of 15 also. I'm gonna hand the witness this and ask him, do you recognize the signature there?
Yes.
And did you sign it?
Yes.
Okay. And that is your signature?
Yes.
Now, handing you what's been marked previously as Board's Exhibit 3 is a partial declaration of candidacy for judge of the Municipal Court of Struthers. And there seems to be a signature there at 512 8th Street. Okay, I'm going to ask, and this is dated January 27th, it's dated 1/28 of 23. I'm going to ask, do you recognize that?
Yes.
And is that your signature?
Yes.
Do you remember signing that?
Yes, I do.
Okay. Handing you what's been marked for identification purposes is Board Exhibit number 4, which is a copy of the subpoena that was served to you by John Teacat. I'm going to hand that to you and ask if you recognize a signature there.
Yes.
And is that your signature?
Yes.
Okay. Thank you. Handing you what's been marked as Board Exhibit number 5, and it is dated February 7th of 2023. There seems to be a signature there. I'm going to ask that you look at it and tell us whether that's your signature or not.
Yes.
And that is your signature?
Yes, it is.
Okay. And handing in what's been previously marked as Board Exhibit 6 is an affidavit that is attested to by Raymond DeLoss and has your name on it. I'm going to ask if that is also your signature.
Yes.
Okay. And you can hand that back. Does the
Can I
board?
ask a question?
Now you can. We've identified every one. Oh, no, two more.
Two more, okay.
Two more. Handing you what's been marked as Board Exhibit 23. This is
This is the sign-in over there, security. And that's
Sign.
outside the door.
this is a sign-in sheet that you signed today. I'm going to ask that you look at it and identify your signature, and if you could put a blue mark by your signature, please.
Check mark, okay.
Yeah. And then lastly is Defendant's Exhibit 24, which is the visitor sign-in sheet that was also signed today. I'm going to ask if you signed this, or it looks like you printed your name, and whether or not that is in fact your printed name on that sheet.
Yeah, I printed it.
All right. Does the board have any questions?
Yes, I do. This is Sandra Barger.
Yes,
Do you know Attorney DeLost?
yes.
Okay. The day that you signed the affidavit, do you know where were you?
We're at a place called Cigarettes for Less in Struthers, Youngstown, Poland Road,
Okay.
playing Keno.
Okay. And what day did you sign that? Do you remember?
Well,
If you can't remember, that's okay.
Yeah.
If you want to look at something, you're allowed to look at something.
yeah. Yeah, I signed it,
Do you know what time of day you signed
I was
it?
about 1 o'clock, 1:30, 2 o'clock, somewhere around there.
Okay. Thank you.
Ms. Best.
U.S.
Yes, Joyce Kilpester. Mr. Savko, on the affidavit, you did not sign your full name. Did you know?
So let's refer to that exhibit. Can I have it, please?
You signed a partial name of S-A-V-K, but you did not sign the other.
Hold on a second. Hold on a second. Mr. Savko, she's referring, you referring to this one? She's referring to Board Exhibit number 6. Would you look at that,
Sure.
please, while she asks you questions? Go ahead.
Yes, you did not sign your full name. Is there a reason for that you weren't able to sign your full name?
Yeah, that's my full name.
There's no O on Savko.
Well, I just write it,
Okay,
I'm,
I just wondered.
Yeah, that's my name. I sign crazy.
Okay.
Does anyone else have any questions?
Mr. Sacco, this is Bob Arnes. That's a petition that you signed. Under what conditions did you remember signing the petition?
Yes.
So, under what conditions did you sign? Were you in a car? Were you sitting down? Were you
No, I was sitting down, yeah,
Sitting down?
and Cigarettes for Less,
Oh, okay.
playing Keno.
Do you recall who had you sign that petition?
Yes, I do.
Who was that?
Oh, did I?
On Exhibit 3, would you hand him Exhibit 3, please? On Board's Exhibit 3, you said that was your signature?
Mm-hmm.
And you said you signed that at Cigarettes for Less?
Yeah,
Do you remember who handed you that petition to sign?
yes,
Who?
Paul DiPinto,
Paul DiPinto.
yes.
Okay. Was it Judge Dominic Leone that had you sign that petition?
No, Paul DiPinto.
Can I ask another question?
Can I see the rest of this petition? Can you get this one? Okay, go ahead.
Joyce Kilpester again. What, did Mr. DeLoss, Attorney DeLoss, come to Cigarettes for Less to have you sign an affidavit?
Yes.
Okay. Is that where the deputy found you also?
No, he came to my brother's house, yeah.
Does the board have any other questions? Well, you can ask a question, you can write it down and have one of us. Mr. Savko, all of these exhibits I handed you, are these all your signatures? And you declaring under penalty of perjury that you signed each one of these documents?
Yes, I signed every one of them.
Do you recall what date you signed the voter registration?
Not exactly what day,
Is it fair for me to say that you signed the voter registration form subsequent to you signing the petition, the nominating petition? Is that fair for me to say? In other words, there was a nominating petition, and then there was a voter registration petition. Do you recall which one you signed first?
the nominating.
Okay.
Did you sign the, Joyce Kilpest again, did you sign the registration day the same day you signed the affidavit?
No.
You did.
The affidavit is dated February 7th. Do you recall independently, other than what's on this paper, whether you signed that on February 7th or not?
I'm not exactly sure, you know,
Signed
on the
it
date.
7/11. You didn't even sign it the day, you signed it on your birthday. 2/7/23 is when we got it. So you would have signed it subsequent to the affidavit.
No, it doesn't matter. He said he signed it.
Well,
And does the board have any other questions?
No, I don't, thank you.
No other questions? Does Lou DeFabio have any questions?
Hi, Mr. Seth.
Yes.
How are you? You're certain, all those signatures are your signatures, correct?
Yes, they are.
Okay. Are you certain about what days you signed what?
No,
Okay,
not exactly.
all right. And, but you know you signed all those, correct?
Yes.
That's all I have.
Mr. Uhas?
I don't have any questions other than what's been asked, thank you.
Thank you. Thank you, Mr. Sefko.
Oh, you're welcome.
You're released.
Can you stay or?
Here,
If either Mr. Uhas or Mr. DeFabio plans on recalling him, I'd ask that he be excused. If he's not going to be recalled by either one of you, then he can stay.
I'm not gonna call him.
Nor am I.
Can I ask him one more question?
Yeah.
Okay, sure.
Who called you to tell you you needed to complete a voter registration card?
Just recently you're talking
Recently,
about?
the
Yeah,
recent one that you signed.
D-Loss, Mr. D-Loss.
Any other questions?
No.
All right, thank you.
Okay.
We would now call Mr. DeLoss, please.
Go, okay.
This is the petition. You took this.
Right, we're going to have you swear in. Since we're not a court, you have to be sworn in.
Okay.
Just so the public knows, usually when lawyers testify in a court, they don't have to be sworn in because there's officers of the court, but we are not a court, so he'll have to be sworn in.
That's fine.
Ray, I think they just want you to sit right there. and they just want you-
Oh, she's gonna swear you.
Go ahead.
Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do. Sit here.
Over there, Ray, right by the book report.
Could you state your name, please?
Raymond D-Loss,
And Mr. DeLoss, where do you live?
130 Lake Shore Drive, Struthers, Ohio.
And what do you do for a living, sir?
I'm currently retired from the practice of law, from being a magistrate. However, I do act as the acting judge in Struthers Municipal Court on a limited basis when Judge Leon is on vacation, sick, or has to go to Columbus for meetings or whatever, he would call me and I would sit in on his behalf. Being that the Struthers Municipal Court is a one-judge court.
Okay, and is your notary up to date and current?
Yes,
Okay. I'm handing you what's been previously marked as the board's Exhibit 6. And on the second page of that, there seems to be a signature. I'd ask that you look at that and tell me whose signature that is.
the second page,
Yes, sir.
that's mine,
And did you sign that as a notary public?
that's correct.
All right. Handing you what's been previously marked as Board's Exhibit 7, which is a copy of the subpoena you got. There seems to be a signature on that. Is that your signature?
Yes.
And did you sign that?
Yes, I did.
Okay. Now, handing you what's been marked as Exhibit 9 is an affidavit of a John Chapella. And if Lou or if Attorney DeFabio or Attorney Uhas would like to look at this.
I have it, and you can refer to me as Lou, it's okay.
Okay. I'm going to hand you what's been marked as Board's Exhibit 9 and ask if you recognize that.
Yes, just so the board understands that I'm here subpoenaed to clarify one affidavit, and that is Mr. Sapkins. However, if you want me to clarify the others, I will.
Yeah, we have them all here, and so
I'll do that, that's
Okay.
fine. Yes, what do you want to know about this?
John Chapella, did you witness him sign
I
that?
most certainly did,
Okay. And is that his signature and your signature?
yes.
Handing you what's been marked for identification purposes is Board Exhibit number 10, which is an affidavit of Michael Agnon. Can you please tell me whether or not that's Mr. Agnon's signature? If that's your signature, did he sign it in front of you?
Yes, yes to all three questions.
Right? Handing you what's been marked previously is Board Exhibit number 11, which is an affidavit of Michael Du Bois. And I would ask you the same series of questions on this affidavit.
Yeah, do both, yes. Go ahead.
And Board Exhibit 12 is
So
an...
the answer to these questions are yes, all yes.
Okay. And on a Joseph Vanden Hoove Jr.,
Yes,
this has been marked as Exhibit 12. I'd ask you the same set of questions.
the answer to your set of questions are all yes.
Now I'm going to move to a Tara Sodman.
Yes,
That's Board Exhibit 13. Is that your signature?
yes it is.
And is that Tara Sodman's signature?
That's correct, that's her signature.
And did she sign that in front of you?
Yes, she did.
Okay. And Board Exhibit 14 is Jennifer Agnon. I'd ask you the same questions.
Yes, that is my signature, that is her signature, and she signed in front of me.
Okay, and handing in what's been marked for identification purposes is Board Exhibit 15, the same questions for James Sodman.
Yes, that is my signature. Jimmy Soderman's signature, and it's signed in front of me.
All right, and Board Exhibit number 16, it looks to be a signature of a Christine Johnson. I'd ask you the same series of questions.
The answer is yes to all three questions.
All right, Board Exhibit number 17 is a looks like a Teresa Romeo. I'd ask you the same set of questions.
Yes to all questions.
Okay, board exhibit number 18 is an affidavit of a Ruben Gutierrez. Same set of questions.
Yes to all questions, Attorney Beatrice.
Board exhibit number 19 is a signature of a Kelly Agnon. I'd ask you the same set of questions.
Now, the answer is yes to all three questions, Attorney Beatrice.
Okay. On exhibit number 20, which is a Megan Du Bois, I'd ask you the same set of questions. Is that your signature?
That's correct, that's my signature.
Is that her signature?
That's her signature, that's correct.
And did she sign that in front of you?
Yes, she did.
And board exhibit number 21 looks to be an affidavit of a Robert D'Amico. Did Mr. D'Amico sign that affidavit in
Yes,
your
he-
presence?
Yes, he did. And that is his signature
Okay.
and mine.
Do you recall on the, where you had Mr. Savco sign his affidavit?
Yes,
Where?
at a small establishment on Youngstown Toland Road in Struthers called Cigarettes for Less.
And Mr. Chapella, do you recall where you had him sign his affidavit?
Yes, it
Where?
was outside Judge Leon's private law office. He was in his car, I had to go out to his car. He wound down the window because he's disabled.
All right. And a Michael Agnon, do you recall where he signed his affidavit?
Yes.
Where
In
was
his-
that?
In his driveway. We had made arrangements to meet him at his house, and he signed his affidavit in the driveway, and I stayed in the car with the driver's side window down.
All right. And Michael Du Bois, do you recall where he signed his affidavit?
Yes, at his home.
Okay. And did you see him personally sign it?
Yes,
All right. Joseph Vanderhoef Jr., do you recall where he signed his affidavit?
yes, he signed his at Judge Leon's private law office. He pulled his car up to the office door. I had to go out and sign it, execute verify his signature there because he's disabled.
All right. Tara Sodman, do you know where she signed her affidavit?
Yes.
Where was that?
It was outside the bocce courts at St. Anthony's establishment in Struthers.
Okay. And Jennifer Agnon, do you know where she signed her affidavit?
Yes, the same place.
The bocce tournament?
Yes,
Okay. And James Sodman,
yes, same place.
bocce?
Bocce.
Do you like bocce?
No, I don't. I've never played it, but let me tell you, it's big in Struthers.
All right. I'm assuming the same answer would be for Christine Johnson?
Yes,
Bocce?
yes,
Teresa Romeo Bocce?
yes. That set was all easy. I just sat there and they came to me.
Okay, so Ruben Gutierrez, same thing.
Yes.
Kelly Agnon, same thing.
Yes,
Megan Du Bois, Robert D'Amico.
yes.
Okay. I don't have any further questions. Does the board have any questions? The board has no questions?
Yes, I do. This is Sandra Barger. Did you talk to Mr. Safco about the voter registration card? Did you-
I'm not sure, I don't understand your question.
Okay, were you involved in the new voter registration card?
Yes,
Okay.
yes, he signed that at the time I verified his signature as a notary.
Okay, so it was done at the same time as the affidavit?
Yes.
Okay.
because as you guys know, the registration does not match to where he's residing at now.
Correct.
Any other questions?
Where did you do that?
At the same place, at Cigarettes for Less. No,
Do you know what time of day that was?
Pardon me?
Do you know what time of day that was?
Oh, jeez, what time of day was that? I think it was a late morning of the day that's on the affidavit. I don't
On
know.
February 7th.
Yes, that would be.
Thank you.
Okay.
No further
One more
questions.
Mr. DeFabio?
No questions.
Mr. Uhas?
I do have a couple. Do you have the affidavits in front of you, Mr. Gloss?
They're all right here.
Could you just hand it to him, please?
Which one do you want?
Starting with 9.
Could you identify John, the exhibit, actually?
Yeah, I just said 9.
No, like the name.
No, the
Oh,
name.
John Chapella, according to what she said. I don't have a copy, but I was taking notes.
I don't have it here. There should be, there are in order 6, 7, here it is, 9, yes, I have it.
Okay, so humor me, I'm just gonna ask you a question about each one of these affidavits, because I need to make a record. Can you tell me what date Exhibit 9 was signed?
What date it was signed?
Yes, sir.
February 7th.
Okay. Could you look at Exhibit 10, Michael Agno?
I'm sorry, I already screwed this up here. All right, yes.
What-
I
what-
have this, yeah.
What date was that signed, Mr. Kolosky?
That was signed on, that was signed on February 7th.
Those two affidavits I just asked you about, do you know if those were signed before or after the Board of Elections meeting on February 7th?
Before or after, those had to have been signed before, because their meeting was at 4 o'clock. These were signed during the day, in the morning of the 7th.
Okay. Would you look at Exhibit 7? That appears to be Michael Du Bois. I don't know if I'm saying that right.
No, Exhibit 7 is just my signature.
No, I'm sorry, 11. 11. Did I say 7? I apologize.
Yeah, that's okay. 11, yes, go ahead.
Is that Michael Du Bois?
Yes.
And
Dubos, yeah.
Dubos? All right, thank you. And what date was that signed?
That was signed on the 7th.
And are you saying that was also signed before the board meeting?
Yes.
All right. Would you be kind enough to turn to Exhibit 12, please? Take your time if you need to put some of them away.
No, that's okay, I'm with you. I may not, he may want to.
Who's that affidavit up, John?
12 is Vanderhoof? Is that how you say it?
Yeah,
Vanderhoof?
it's hard to pronounce, yes. We call him Joe Van.
No, I don't have a lot of room to talk with my last name, so I'm not gonna say it.
We make it simple. Mr.
So that's Exhibit 12. Do you have that?
Yes,
Would you tell us for the record, please, what day that was signed?
that was signed on the morning of the 7th,
Okay.
February.
And 13 is Tara, is it Sodman?
Tara Solomon, yeah.
Okay.
Oh, thank you.
You have that in front of you, Mr.
Yes,
Bloss?
yeah.
All right. What day was that signed, please?
That was signed the 19th of February.
All right, and would you be, you already told us that was at the bocce tournament,
Yes.
correct? All right, so all of the affidavits following 13 that I think you testified, all of them were signed at the bocce tournament or event, correct?
I don't know.
All right.
Let's take a look.
Let's go through them then.
13, 14.
14, please.
14 is yes,
That is Jennifer Agnon, am I correct?
yes.
And what,
Bocce,
and what day was that signed, please, Mr. Gloss?
the 19th of February.
All right. And if you would, 15, please, which should be James, however you say it, Sodman?
Sodman, yeah. That's the 19th Bocce tournament.
Okay. Exhibit 16, I believe, is Christine Johnson.
Yes, the 19th of February, that's the Bocce tournament.
All right, thank you. Exhibit 17, Mr. DeLoss, should be Teresa Romeo.
Yes. That's the bocce tournament on the 19th of February.
And Exhibit 18, I think, is Ruben Gutierrez, am I right?
Yes,
What day was that signed,
the
please?
19th at the bocce tournament.
Exhibit 19, I believe, is Kelly Agnone, is that right?
Kelsey,
Kelsey, okay, thank you. And what day was that signed, Mr.?
19th of February at the bocce tournament.
And Exhibit 20, I believe, is Megan, is it DuBose?
Dubose, yes.
DuBose? What day was that signed, please?
February 19th at the bocce tournament.
And how about Exhibit 21, which I believe is Robert D'Amico?
Yes.
What day was that signed, please?
It's February 19th at the bocce tournament.
Okay. Then with regarding Mr. Savko, I think you said that the registration was signed at the time of the affidavit, correct? Do you have something in front of you that would tell us what date that is?
No, I don't have the change of registration, but I have the affidavit.
Okay, so that would refresh your recollection as to the date?
Here,
Yeah,
we have one. Hold on.
Exhibit 5.
okay, exhibit 5.
Exhibit 5?
The new one, yes.
I'm sorry, would you identify Exhibit 5, say again then?
Well, this is the voter registration that Richard signed. He signed it in front of me, but that wasn't required apparently. He just signed it.
And what day was that he signed it in front of you?
Oh, I can't see the date, but it was the exact same date that, I don't see the date on here, but it's the date that he signed his affidavit.
All right, so if you could see the affidavit, would that refresh your recollection?
Yes, absolutely. It must have been. Thank you.
So what exhibit do you have in front of you now,
Yes,
sir?
I have exhibit 6.
All right.
This is affidavit. It's February 7th. That was at the cigarette shop.
Very good. And about what time, sir? At the
I
cigarette
was
shop?
I think that one was late morning.
That's all Thank you, that's all I have.
Okay.
Does the board have any other questions?
Mr. DeLoss, Attorney DeLoss, you absolutely watched every single person sign these affidavits.
Absolutely. And as these lawyers know, I better. That's how you lose your law license.
Right.
And the affidavits were all signed in different locations?
I'm sorry?
Affidavits were signed in different locations?
Yes, they were.
Well, no, either at the cigarette shop or the botch.
Well, no, or people's homes.
Or people's homes, yeah.
Or at the private office of the judge. They never came into the office, I had to go home.
Bob, Sandy, any other questions? Okay.
There are some more affidavits, do you guys understand?
We didn't submit them, that's okay.
Oh, you didn't say? Okay, I wasn't aware.
All right, thank you very much, Mr. Bella.
Okay, you're welcome. Hey, stay. Okay, stay, right.
Unless Mr. Uhas or Mr. DeFabio is planning on calling you,
No,
No,
you stay right.
okay.
then you're free to stay.
I can sit next time, buddy.
Okay, we're gonna let Lou, we're gonna turn it over to Lou. Do you have anything else that you wanna present to us?
Okay, my understanding was you were gonna vote based on your own witnesses, but are you saying you want me to go forward on my,
I mean, we could, if you want, we could just take one vote. Or we could just vote on our witnesses.
I
and-
would like to go into deliberation for our attorney.
All right, so everyone's gonna have to exit outside of the attorney that represents us and while we deliberate on our own witnesses.
Attorney Beatrice, please cite the specific section of the Ohio Revised Code that allows you to go into deliberations.
Deliberation with counsel is
That's for pending litigation or current litigation. I know that you've done it before, I believe it's illegal.
It's adjournment for deliberation.
You can't do that.
yes,
please cite the Ohio Revised Code that tells you.
I will ask our attorney when you're going.
Lynette, do you happen to know the?
It's attorney-client privilege, it's case law. This is not a public hearing, this is a hearing, this is not a public meeting.
It's still a public body.
I understand that. They are going into deliberation.
We're not gonna vote.
They're-
I know, I don't believe
They're
we're going to
quasi-judicial,
deliberations.
they are permitted to go into executive session, it's not executive session, I want to be clear about that. They're deliberating.
Please point this to me, I
I
strongly disagree.
don't have the case law in front of me.
Because I don't agree it exists.
It does.
It does not exist.
It's the law. It does.
I've been a reporter here in Youngstown for 27 years, and I do not see anywhere in the Ohio Revised Code that says that you can do this.
It's attorney-client privilege, which is statutory, and it's also common law. And in fact, the Ohio Supreme Court just recently ruled that the attorney, in fact, we just had a case in front of Judge Sweeney. We just won a case, a motion to dismiss, on a case where they went into deliberations on a protest. So it's case law. That's all I can tell you. I'll be happy to give it to you.
If you would provide it to them.
I can, but I'm going to agree at it. But they are permitted to do that.
We'd ask everyone to exit and then we'll call you back in.
Mr. Beatrice, before you do, I would renew my, I made it sort of in an opening statement, but I would renew my objection about considering new evidence for the reasons I've stated previously.
Okay.
Thank you.
Mr. Skolnick, the prosecutor is going to hand you the opinion.
This is executive session. You never called an executive session. You called it deliberations.
Okay. Well, tomato.
It's a big, is it executive session or
The point
or
is,
deliberations?
we had questions for our lawyers. We have a right to have that held in confidence. Any pending or imminent court actions, both of these candidates have lawyers. It's potential that there's pending or imminent court actions, so here's what we've decided to do. We are gonna let Mr. DeFabio put on his case and any evidence he has. We're gonna let Mr. Uhas put on any evidence or make any legal arguments he wants to make. And then when everyone's all done, we're gonna go into executive session to talk about pending or imminent court actions and get some more advice from our lawyer, which we have a right to do confidentially. And then when we come back out, we will announce a decision, and you can watch us make a motion and do whatever we have to do at that point. I can tell you that we've not voted, we've not made a decision. The only decision we made was to just let everyone have their say, and then we'll go into executive session, pending or imminent court action, and then we'll come back out, and then we will rule on all matters before us. So, Mr. DeFabio, if you want to.
Yes, may I have just 1 minute, and then I will be up. Okay. So, in terms of our motion for reconsideration, as I said at the beginning of this, it is our position that there are already 46 valid signatures. And I'm going to have, and all this is a color copy that I had made that shows the check marks and the valid signatures along with red numbers showing the count of the vote. I know when we were last here, there was a dispute about 46 or 45. My opinion, then and it is now, there are 46 valid signatures on this. I have a copy of each for you. And I'm gonna move.
Can I ask a question on that?
Yeah.
Are you saying, I want to make sure I understand what you're saying. Are you saying even without Mr. Savko's affidavit, you still have enough signatures on the other affidavits you brought in?
Yes.
That's your position?
And that's my position.
That's what I was saying. That's what I've been saying. That is their position.
However, I'm also saying with Savco and the other affidavits, we're well above 50. And I hate to keep repeating myself, but this is exhibit one. And I made a copy for each, and I gave a copy to Attorney Dupas. I even went so far as to come down, actually Thursday, but I didn't get them till Friday, because I wanted to make sure I had the latest checks of the petitions. And that's what I used for this. This is, you can tell the last date is 2/16/23 on here. And there is next, every check signature has a yellow highlight.
Who added these numbers? Can I ask that?
We did, yeah.
You did.
We just simply counted. It's just, truly, it's math. It's just math. So I do believe there's 46 valid signatures. I believe the 4 affidavits that were previously accepted prior to the certification would put us at 50. I do believe that even if there was an insufficiency, the insufficiency was based on questions relating to the signatures. The affidavits clear that up. These are the people. This is where I live. Yes, I signed this. That puts us well above 50. But at a base level, I think we're at 50 to begin with the 4 original affidavits that were admitted on February 7th. With Mr. Savco, we're at 51 in my opinion. But even if your count is correct, and if it's 45, which I don't think it is, I don't think you can contest the, even if the count was 45 with Mr. Savco, we're at 50.
What's the check?
Yeah, somebody checked it, but it's a printed signature, we have to check the registration on that. What was the name? It's on the last petition, Francis.
Okay, but,
Bill or something.
no,
He's here.
He's here, by the way, and he'll be, we can call him to testify if you'd like.
well, it's not my,
All right, bring him up. Gallo.
Well, I'm gonna object to that for the reasons I've stated about, how many times do you get to do a reconsideration?
wait a minute, John. What the argument and the record, it's my understanding that Mr. DeFabio is trying to make is, prior to us taking any more affidavits or anything else, based upon the affidavits he brought in with the petitions that day, he's at 50 signatures. Am I misrepresenting your argument?
No, you are not.
Okay.
However, the gentleman we heard from was not a registered voter, so we can't.
He's
take-
saying he still has 50 signatures if you take Mr. Savco out. That's their
No.
position.
Okay.
Well,
Okay.
he gave us 46 signatures here.
There are 2 check marks next to Gallo. There's nothing indicating Gallo's signature wasn't accepted. And in fact,
If you look at the top row, it says 1 valid.
that's right, because the second person is not genuine, and that's Rob, whatever, Seymour.
I don't know. Well, he's here, let's come in.
And I would tell you,
He printed his name.
what's that? Did you give me the affidavit? Yes.
I don't know.
Is you said Francis, is it good?
Gallo, I believe.
Gallo,
Yeah.
he's here?
Yes. And
Lou, it's your case, it's your,
I still object because you're considering new evidence when you've already had a hearing. You decided to do that hearing on February 7th, maybe you did it out of order, but how many times do you get to bite at the apple? Well,
okay, here's what he's saying though, John, and this is why I'm giving him the chance. Our board employees approved this petition with one signature on it.
okay,
We checked it and said it's a good signature, okay? And Lou is saying that if you count that one signature on that one petition, plus the affidavits they brought in before, they are at 50, even if we don't consider anything else.
okay. Then it seems to me that you stop and you take a vote on whether you agree that that's true. And if you want to consider the Safco issue, then you do that as well. But you certainly do that before our protest, because if they're two separate procedures. The protest is different, a challenge is different from a reconsideration. And if you don't get there on the reconsideration, and I don't think you do, both legally and factually, but if you don't get there, then there's no need for us to challenge. Just like we withdrew our first challenge tonight because we knew you guys were issuing subpoenas on that issue. Why are we going to redo the same thing four different
Because
times?
I think you have a process argument, and we're willing to entertain that, okay? And whether you force us to take the vote now or later, I still want to hear your process argument. And we'll take that into consideration when we're voting.
Well, part of my process argument is that you shouldn't be hearing the reconsideration because you've already done it. But if you're doing that, you should certainly vote on that before you decide, because if you decide that he's not on the ballot, there's no reason to hear a protest because it's moot.
Well, I think the board's position is we want to hear from all sides, and then we're going to take every argument into consideration, John. I understand you have a process argument, and it is not falling on deaf ears. I hear what you're saying, that, you know, the bar's pretty low, and did he trip over the bar and not get over it? I hear that argument from you. I think the board wants to hear your arguments as to whether or not we could even do what we did, and I think out of fairness to you, you know, we should just hear all the arguments and then we'll issue a decision.
Okay, with all due deference, I kind of think that's what got you in trouble in Ongaro. I think it's what got you where you are now in this case. And obviously, you're going to do what you're going to do, but I think it's incumbent upon me to point it out. There are two separate procedures, and you just indicated that you're going to go back, you're going to listen to everything, and I know that sounds great, because it's like, geez, we want to be fair and we want to hear everything. But that's true within the process that's defined in the law. And by law, a challenge and a reconsideration are two different things. So you're ipso facto violating that when you say we're going to hear everything at once and then go back and vote on everything at once.
Okay, so to remove an argument that you might have, the chair would entertain a motion to certify Don Leon's petitions to the ballot. Is there a motion? There is no motion. Is there a motion not to certify him to the ballot? Well, we gotta do one thing or the other. We either have to accept his petitions or not accept his petitions. So what I hear Mr. Yuha saying is, he's gonna have an assignment of error that says, since we didn't vote on it to begin with, that that's flawed. So to remove that argument, I'm asking the board, let's vote on the petitions, up or down. And I'll entertain a motion either way.
Well, I would make a motion that we only have 49 valid signatures in his petitions
Okay.
from our records.
Okay.
Correct? Because we had a,
Well-
Sasco is not a registered voter.
No, that's not what the evidence showed. I mean, well, there's a motion to only accept 49 valid signatures and not accept anything else. Is that my understanding of your motion?
did not accept the
We have
first
two
set.
sets of affidavits.
Well, the first set we accepted to look, we looked at, correct?
Correct.
And what Judge Leon's lawyer is saying is, even if you don't consider anything else, they're still at 50 signatures.
And Gallows seems to be, I'm assuming, is the signature that is causing us the difference.
Correct.
Because originally, it was written as valid, and I don't see anything anywhere that says it's not.
I agree that we checked that as a valid signature.
Right, on the double and triple check, we did not because it was printed.
Right, but we reconsidered it, and so we reevaluated it.
Where, okay, so I do not have a document that says it's not, and I got the latest set of petitions that you guys had in your, so is there somewhere that shows that's not valid? Because on my set, even the one that I submitted with the coloring, which is the one I got on Friday, that not valid does not appear.
All right, so let's do it this way. Is there a motion to accept whether or not Dom Leon, as a candidate for the municipal court in Struthers, has enough signatures on February the 7th, 2023? His lawyer has laid out an argument that he has 50. I've heard that he doesn't, but it's clear to me that he has 50. So I'd like to see what the board's position is. And then we can move to whether or not he has a right to then supplement the 50 with more, even though 50 would put him right there.
So does he have 50 or does he have 49?
We think that, I think our staff and we're in agreement, and Joyce looked at them as well, the three of us, we think that Francis is a printed signature. It should have an affidavit, but he's here to testify as well.
So does the board want to
But
hear?
is he in the first affidavits or is he in the
No,
second?
he's not in any
There are no
affidavits.
affidavits.
Okay.
I have
Because
a-
we never said,
Right.
we never notified him that that wasn't a good
But
signature.
did we have to?
Well,
Isn't
if you're
it the
gonna
candidate just wanted
discount,
one?
yeah, if we're gonna disqualify a signature, we gotta let the candidate know this is not a good signature and it's checked. I mean, going back to Mr. Uhas's argument, we can't say it's a good signature, oh, we changed our mind, it's a bad signature. It's either a good signature or a bad signature. And there's no affidavit because no one notified them that we weren't accepting that signature.
And which one are we looking at that's not,
Number 46.
okay. So on our.
What's HG?
I think that's MG.
No good.
But the Francis above him is good.
It's checked.
It's checked, there's nothing that says it's, you see what I'm saying? Nowhere does it say X, and at the top of the one sheet, it says one ballot. So there's nowhere that I can find that says that was a non-valid signature. All I see is a check, which my understanding means it's good. In fact, there's two checks. There's a check on the left and a check on the right.
I don't disagree with that.
But this is the petition where, Joyce, that you did here, that would be this one, there was only two signatures, and one was valid and one was not.
valid. I still got the 45 or
No, you got
49.
49.
Well, he just showed us here where he got the 50.
The number of colored petitions will count up to 46.
What?
You want to compare it to your own petition?
But you said he got you 46, correct?
If my,
Well,
Yes, that's his
That's
argument. He
it,
got the
yeah.
46. They
and we
submitted
accepted
5 affidavits, one we discounted, and their position is that even if you discount the one, we're still at 50.
that's correct.
Am I laying out right?
That's it. And that's without even taking into account the affidavits of the testimony you've heard today. The additional affidavits that we supplied.
But we haven't accepted those.
I understand.
Well, we did accept the first batch.
We
Yes.
accepted the first one.
And so if we accepted the first batch and we said that 46 was good, we can't go back now and say 46 is bad and leave them no remedy to try to rectify it. I mean, I just want to be fair to everyone. If we are now saying that 46 is not a valid signature, we have to at least let them know that we changed our mind on that when we've never voted on that.
Mr. Beatrice, can I ask evidentially, is that the signature that's in contest, or is it some other signature? Do we know that?
No, I'm
Why
assuming.
are we limiting it to 46 then? And why isn't that the board's determination?
Because we have to rule on the validity of these petitions. And our staff goes through and they do a signature check, okay? On some of the signature checks, they said no good. They brought in 5 affidavits saying that is in fact my signature. We accepted those. One of the affidavits wasn't good because the guy either wasn't registered or registered at the wrong place, which left them 4 affidavits that we had accepted, which according to their count, and according to our count would be 46 plus 4 is 50. We don't even have to get to the remainder of anything else, if I'm understanding the argument that's been laid out by Mr. DeFazio. And I'm overly laying this out so there's a record that some court can look at and not say that we didn't fully consider it. So either we are gonna, Mr. Uhas has requested, and so since he's requesting it, he can't then go to court and say, well, they voted on it, even though I asked them to vote on it, okay? So if Mr. Uhas has requested that we vote on the petitions, I agree with that. If that's what he wants, fine, we'll give him that. And then he can't then go to court and say, well, they voted on it, because he wouldn't be going into court with clean hands. He asked us to vote on this first. He can't go to court and say, well, they voted on it first, they shouldn't have done that. We're doing that at his request.
Well, you're doing that at my fallback request. My request is you shouldn't be considering it all because it's already been considered. But to the extent that you're not ignoring that argument, then yes, I think you do have to vote on the reconsideration before you vote on before you hear the challenge. Because if the vote is down, then the challenge is moot. But that's my fallback position. My position is you already did a reconsideration on February 7th.
Yes, and the point is that on the affidavits that they submitted on the 7th, their position is they're still at 50 signatures. That's their position. Now, whether or not a court upholds that or not, I don't know. I'm just laying out what their legal position is. Okay? We have approved 46 signatures, according to this. Am I wrong, Tom?
Through our own paperwork.
You're not wrong, but just on administrative overview, that included the 3 of us. We didn't count that last
And the
signature.
same, that even in the same token, we received 9 affidavits, 3 of which were people who were valid, so they understand the process, right? 6 of them.
Right, we either have to vote up or down on the petitions.
We should look at our own, which Sandy's doing right now.
I'm trying to do.
But am I to understand that that 46 signature is Gallo? That's the one that's the difference between 46 and 45?
So,
We believe
Okay.
so.
yeah, it's only when that can be.
But no one notified him of that.
That's correct.
And all I'm saying is, had we notified him of that,
Yeah, clearly printed just on the first and second check, and we caught it on the third.
There's not even an X or anything there, unfortunately. You see what I'm saying? It looks as if that's a valid signature. We accept that as a valid signature. And we went along also that 46 had originally been written on the first petition to show the numbers. And all you had to do was count up the check marks.
because on the 5th review, you said, oh, that's not a valid signature, even though we had counted it before.
Well, when you counted it before, isn't that, you'll get this term, Mr. Beatrice, res judicata. You've already considered those signatures and you've decertified. So as I'm hearing him today, the only thing that he's saying if you allow them the reconsideration, is, hey, do the math and count again.
All right, well, Mr. Uhas keeps talking about decertifying. We were certified, so there was no reason for us to do anything further at that point. And quite frankly, I argued, and so the record's clear, they didn't have the opportunity to reconsider a certification. The opportunity was his protest, and the opportunity would have been for you to show there weren't 49 signatures, or weren't 50, and mine would be to show there are 50.
That's why I think, now you've just flipped me the other way, Lou. I just think that we should hear everyone out and then make a decision and go from there. Are you resting, Lou?
I'm gonna call Mr. Gallo.
Okay, call Mr. Gallo. Go ahead. What are you gonna say?
I'm still objecting for the record.
Okay.
I'm good, just grab a seat there.
Can you swear him in, Lou, please?
I will.
Or do I have the court reporter?
Okay, you swear him in, how about that?
Raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, Mr. Gallo, would you state your full name for the record?
Francis S. Gallo,
All right, what's your address, Mr. Gallo?
518 West Wilson Street, Struthers, Ohio.
Are you a registered voter?
Yes, sir.
Registered Democrat?
Yes, sir.
Okay. Do you recall signing a petition, a nominating petition for Judge Dominic Leo?
Yes.
Okay, I'm gonna hand you what's been marked as, and this is just the front page, because the back page has no signatures. What's been marked as Plaintiff's Exhibit 3. Would you look and see if you see your name on there?
Yes.
Okay. What numbered line, if you could tell, is your name?
Number 1, top.
Number 1 top. Do you sometimes sign your name in print?
Yes.
Okay. And did you sign that petition?
Yes, sir.
And by signing that petition, did you intend to sign the nominating petition so Dominic Leon could be judge?
Yes, sir.
And that's your signature?
Yes, sir.
Okay. Have a minute? That's all. No, they get to,
They get to ask you questions, and Mr. Gallo.
Yes. Oh.
Let's just stay there.
no. I'm gonna leave that here.
Well, are you having me go first, or are you guys going first?
Doesn't matter, whatever you prefer, Mr.
No, you're the board, that's why I sat, because I assumed the board wanted to go first. but-
Mr. Gallo, you've seen this with
Yes.
Lou, you did not mark this as an exhibit, so I'd ask that you mark it.
I did.
Did you mark it as an exhibit?
Plaintiff's 3.
Okay. Is that a printed or written signature of yours?
That's the way I write.
That's the way you write.
Yes.
Has anyone ever told you that was not a valid signature of yours?
No.
Have you signed other petitions like this?
I sign my name always like that, sir.
That wasn't the question. The question is, have you signed other nominating petitions like you signed this nominating petition?
Yes.
Do you know for whom?
No.
Go ahead.
Mr. Joyce Kilpatrick, when you go to vote, how do you sign your name? On the poll pad,
Francis S. Gallo.
but do you print it or do you sign it?
I print.
Anyone else have questions? Mr. Uhas?
Just a couple, Mr. Gallo, when did you sign that petition that's marked as Plaintiff's Exhibit 3?
Pick it up, look, it's there.
1/30 of 23.
Okay. Where did you sign it?
At church,
What church, please?
First Covenant.
And so, was that on a Sunday?
Actually, it was on a Monday,
Okay, what time of day?
about 7 o'clock
PM or AM?
PM.
PM, all right. And who is the person that presented the petition to you for signature?
Paulie DePinto.
That's all I have, thank you.
Any further questions? Okay,
He could step down.
yeah, he could step down.
You want the recorder to have the original with it?
Well, she just needs an exhibit for the record.
And this actually is front and back, so
Okay.
I thought it was just the front.
I would like someone from our board to explain on the record, did we count that signature or did we not count that signature going towards the 50?
For the certification, do not count that going forward to get to the 50.
When did we not count that?
February 7th. We didn't have enough,
It is clear to me that there are check marks at that signature, correct?
correct,
And underneath that signature is not good, correct?
right. We've determined that prior to certification of petitions on February 2nd, that signature is no good. That's why they lack signatures. That's why when the board accepted those 5, it took from 45 to 50, not 46 to 51.
You would agree with me that at least from the documents here, it looks like a valid signature?
That's correct.
I hate looking at signatures. I hate it. I hate it. We had Mr. Savko, he signed 5 different ways, okay? And I have no reason not to believe, I'm not a handwriting expert, but I'll take people's words that that's their signature, okay? Mr. Uhas, I would like, where the board would like to hear your process arguments, what we're doing wrong, and the floor is now yours.
So, I think I've already kind of laid it out, which is that, as I understand it, the petitions were filed, well, the deadline was February 1st. You had a hearing on February 7th. I obviously wasn't present at that hearing, but from what I've been able to find out, somehow you took evidence. If you're a quasi-judicial body, you're taking and you're acting as a quasi-judicial body, and you're taking evidence. I don't know how somebody knew to show up with 5 affidavits, but apparently when there was a question about the number of signatures, Judge Leon and his lawyer showed up with 5 affidavits, as I understand it. And you accepted them. Okay, you accepted them. There's a procedure for reconsideration in the law. There's a procedure for a challenge. Clearly, Judge Leon's not challenging his own signatures. So whatever that hearing was on February 7th, where you took evidence and acted in a quasi-judicial manner, I would assert that's it. And whatever facts were determined then are it. And so now, when he wants to come back and do it again, it isn't, look, it has nothing to do with trying to keep him off the ballot now. It's a question of, when people come down here and file petitions, is somebody going to say, well, there's a first set of petitions, and you didn't do those right, so submit another set, and then when you have that, we don't have the right number of signatures, okay, you show up with some affidavits, and we'll have a hearing without notifying anybody on that we're going to have a hearing on that issue, and take evidence. And now, when you voted at the February 24th, not to allow them on the ballot, now you're allowing again what I submit you've already allowed. And I just don't think, again, it has nothing to do with Dom Leon personally. I personally love the guy. It's not that. It's a question about what the law is. And when the courts look at what you do, part of what they do is they look at one of 2 things. Is there fraud and corruption? From what I've heard you say and from what I've seen, there doesn't seem to be any evidence of that. The second thing is, did you abuse your discretion? Mr. Beatrice knows better than anybody in this room what an abuse of discretion is. It's a legal term, but it basically means that you're acting unreasonably because you're not following the law. So if you take all that in the context of both the 14th Amendment Equal Protection Clause and the corresponding provision in Section 2 of Article 1 of the Ohio Constitution, it's a question of how is this candidate getting treatment that other candidates don't get? And that should sound familiar, because if anybody listened to any of the snippets of the arguments yesterday in the Supreme Court, that's what some of the justices were raising. When you do that, you're automatically making it unfair for somebody else who doesn't get that same treatment.
May I respond?
I just want to say one thing. I want to correct the record. We did not take evidence. It said signatures, it didn't look like their signature, and they said, that's my signature. That's not taking evidence. That's just someone saying, that's my signature. Okay? We are tasked by Ohio law to compare signatures. I hate it. Because even my own signature never looks the same in the morning as it does in the evening, okay? And so when people sign these and we can't make out whether it's their signature or not, and they said, yeah, I signed it, that's not taking evidence, that's just them saying, that's my signature. I dispute the idea that there was somehow evidence taken when someone just simply said, that's my signature. That's the only thing I want the record to indicate. I don't think we held a hearing. It was just someone said, hey, you said that's not my signature, that's my signature.
You received affidavits, Mr. Beatrice.
We did. We often receive affidavits when people sign things and they say that, and we say it's not them because our staff's not handwriting experts. And so when they say, oh, that's not a good signature, it doesn't match their signature on the voter roll, I mean, that is a lay opinion person saying, well, in my opinion, that's not their signature. If someone comes in and says, that's my signature, well, that's their signature.
Correct, that's evidence that that's their signature, so that's evidence. And you know that affidavits are used as evidence in summary judgment and other proceedings. It's taken evidence.
I understand what you're saying. It's not changing anything other than we couldn't read their signature and they said that's my signature. You want to call it taking evidence, fine. I'm just saying it's a clarification of what they had on the paper where a layperson has to look at a signature and make a judgment call whether that's their signature or not, and they're not handwriting experts. They're just making a call as a layperson. That's all. I mean, and as far as we made no special considerations for Don Leon, we've done this numerous times on different issues where people can come in and say, yeah, that's how I sign my name, or that's my signature. It's not, this is not a special circumstance. I believe in suffrage of the people, and I agree with you, Mr. Uhas. There is a process. You can't just come in here and say, hey, I want to be on the ballot. You got to fill out petitions. The petitions have to have signatures on them. We have to then take those signatures, and lay people have to then compare it to a signature line that they may have written 20 years ago. And we have to make a call whether or not that signature matches a signature on our voter rolls. And that is, all kinds of errors can happen. And so all we do is simply say, is that your signature? And you want to call it evidence? I'm just saying it's a clarification. I guess a court will determine whether or not that's evidence or not. But it certainly seems to me that, this is a low bar, but, I hear your argument, and I'm going to take it into consideration. But you're asking this board to do things that we've not done before, and that is, we've always allowed people to bring in affidavits to say that's my signature. That's something that we've done as a matter of course. If a court says we can't do that, then I'll take that.
But that's not the argument.
But the courts have said we can do that now.
Of course they can. That's not the argument. The argument is, name me one case where somebody has come in and filed a petition, and you've said, no, these petitions aren't right, go back and do it again, and they come back and do it again, and then somehow they show up 5 days later with a bunch of affidavits, and
I don't know how that happened, I'm being honest with you.
I get that. I'm not casting aspersions except to say that you haven't followed the procedures. If you can take affidavits, you can do things. That's what happens when somebody challenges and says this petition is invalid because there aren't enough valid signatures. You can take evidence to hear there are valid signatures. That's what the reconsideration is for. What I'm saying is, when you say this is things you've done before, you've taken affidavits, I'm sure you have. Name me a case where you have allowed somebody to file 2 sets of petitions and then had the procedural history that this case has had.
I hear your argument, I hear your process argument.
Okay.
I understand as a lawyer completely the process argument you're making, and this board has a hard decision to make, okay? Is there anything else that you wanted to?
On the process?
Yeah,
No, not on the process.
all right,
Other
anything
than-
else?
Well, I do, but again, I
Okay.
renew my objection that I shouldn't be making a challenge if if the reconsideration is not allowed.
I appreciate that, but I think the board wants to just hear everything, and then we're gonna make a decision.
Okay, then, honestly, everything else is laid out in the protest letter that we filed. You can lop off the first page and a half. We've laid it out with statutes, we've laid it out with cases in terms of, I don't see any evidence in the record. I see evidence that Judge Leon asked to withdraw petitions, not that he asked to withdraw his candidacy. And I see law, and I've cited it to you, that you can't file 2 sets of petitions in the same election unless you first withdraw your candidacy. And that didn't happen here. The one thing I will change is it does appear, we thought at the time that we filed these that the first set of petitions had been handed back. It appears, someone told me that they are actually here. So the concern there obviously was public records. But it's my understanding those petitions always did remain here. So as we've laid out in here, citing the statutes, he could withdraw his candidacy, but he did not. He could not withdraw his petition, but he did. And we cite the statute in the law where it says the Board of Elections can't accept two sets of petitions in the same election. So, I mean, I can reread the letter to you, but all the cases are there. We've laid out everything for you as to what we think.
What's the date of your letter, Mr. Uhas?
Date of my letter was March 1.
It's a 1 paragraph?
No.
There's
Oh,
a,
it must be a different one.
I have a,
I'm sorry. I'm sorry. It's the protest. Forgive me. Today, March 1 is when I withdrew. It's the protest. It's, what was it, 17? Hold on. Give me 1 second.
February 17th.
Yeah, February 17th. You need a copy?
no, I have it right here.
Okay.
I'm assuming, Mr. Uhas, you want to make this part of the record?
I do. I assumed it was part of the record since it was filed with the board.
We'll specifically make this part of the record and attach it to the transcripts.
But ours are attached. Oh, no. But there's no difference there. I don't know. 46, so if they take football, who's got it? But then, this is not so. Well, this piece of paper, you can say 20. And you add 2 to it.
Mr. Uhas, is there any other arguments or evidence you wanted to put in?
No, I've made the process arguments, I've made the legal arguments, I restate, I think they're 2 separate procedures, they should be treated that way.
Okay,
At the risk of repeating myself, I subsist.
thank you. So we do this procedurally correct, Lynette. We are going to go into,
Wait, do I get to respond?
oh yeah, go, I'm sorry, I'm sorry.
I know you have been dominating here. I at least want credit for being the person that told you the first set of petitions are here. Okay.
He's so credited.
All right, Mr. Udas, when we were talking about the signatures, no signature issue, talked about there's never been a case like this, except for Coble, which is the case that he cites. What Coble did was, he filed petitions to run for the Toledo municipal judge. He gets a call from the board, and the board says, you've got insufficient signatures on your petitions, okay? Coble goes down, withdraws the petitions, files a second set of petitions with the declaration of candidacy, and the board doesn't let him on the ballot on the basis of the very argument that they're making today. You cannot file two sets of them. And no less authority than our Supreme Court rejects the very argument he's making today. They say, of course you could, because, let's start with the language of 3513.052G is unambiguous. You cannot add any language to it or delete language from it. And what that section of the code says is nothing anywhere in the revised code prohibits a board of elections or allows a board of elections to disqualify a candidate who timely withdraws from the race. You have, which is part of the board record, what I've labeled as Plaintiff's Exhibit 3-2, which is a receipt from the board dated January 7th, which is several days before that second set of petitions is submitted, that says withdrawal. That's about as plain and clear as you can get. Withdrawal means withdrawal. He did exactly what Coble did. Now, I don't know if Coble ever won that race or not, but he, he did the very thing that Judge Leone did. Judge Leone came down to the board, I believe Mr. McCabe was there, and he hand wrote a note withdrawing his petitions, and he walked away, and he went out, got more signatures, and several days came later, and filed that. That withdrawal is a withdrawal. It doesn't disqualify him. And if, listen, the Secretary of State's handbook, which is on page 380, says the same thing. A candidate who timely withdraws that person's candidacy prior to a board action on their nominating petition and prior to the filing deadline may file a new petition, even if that petition is for the same office to be elected at the same election as the withdrawn petition, as long as the board has not officially acted on the petition, all of which Judge Leone meets those qualifications. I mean, listen, I'm not going to get up here and cite, you know, the Equal Protection Clause and the Due Process Clause. The Ohio Supreme Court over and over and over again has talked about open and competitive elections. Okay, that's the goal. Jim Malone is essentially trying to say, hey, look, we're going to try to put somehow form over substance. It was a withdrawal of the petitions, not the candidacy. Well, they're on one form, okay? You can't withdraw one without the other, either way. He did everything that he was advised to do here. He did what the Supreme Court says is okay in Coble. He did what the Secretary of State says is okay in the Secretary's handbook. I don't know what else he could do, and surely this is not the first time, as we know from Coble, but I'm sure it's not the first time even in this county that a candidate has withdrawn his candidacy and then filed before the deadline a second set of nominating petitions. You know, the statute says, by the way, the board shall not accept a second set of nominating petitions. But the board did accept them here, which tells me
The board relied on the withdrawal, that's why we got a receipt that says withdrawal, and that's why they took the set of petitions that we're here arguing about today. And I think that's all I have.
So I want to make sure I understand your argument, Mr. DeFabio. Your argument is that legally, Mr. Leone is allowed to withdraw his petitions
Correct.
and then resubmit another set of petitions.
Correct.
Okay. And Mr. Uhasz, your position is he can't do that.
Correct, and that is what the case says. If you look at page 3 of my letter, it explains exactly what the court did. The Board of Elections rejected the nominating petition, refused to certify him as a municipal court judge. The court found that because the candidate did what Judge Leone did not do here, withdraw as a candidate, and refile a second nominating petition before the deadline, it was error for the Board of Elections. So don't look at the receipt that he handed you, look at your own records. On January 27th at 1:22, you file stamp something that says, I don't withdraw as a candidate, which is what this case and the statutes require. It says, I withdraw my previously filed petitions. You can refile the petitions if you withdraw as a candidate. You can refile them. You cannot withdraw your petitions, and that's what he has to do, not to withdraw his candidacy. So that case is on point.
It is for us, and let me just add that, again, 3513.052G, I'm sorry, H2A, timely withdrawal means withdrawing as a candidate before the applicable deadline for filing a declaration of candidacy, declaration of intent to be a write-in candidate, or nominating petition for the subsequent office.
Can I have that section again, please?
This particular one is 3513.052. And by the way, if you want to see what the Supreme Court said at Coble, you need look no further than the dissenting opinion of Justice Lassinger, who says, however, we are now disavowing our reading of the pertinent statutes to allow any candidate to withdraw a petition and file a second petition for the same office before the filing deadline. She makes this as clear as could be, that's what the case is saying. It can't, if the Secretary of State says it, and the Ohio Supreme Court says it, and the legislature says it, I'm going to take their word over what Attorney Uhasz says.
Well, that's why we have an attorney here to advise us, and someone who acts as his own lawyer has a fool for a client, so if there's no more arguments, since this definitely is pending or imminent court action, I would entertain a motion that we go into executive session so we may receive legal advice on what is obviously two disparate interpretations of a statute and of a case, and get the opinion of our attorney. So I would
So moved.
Is there a second?
Second,
Would the director call the roll?
Ms. Galpesta?
Yes.
Attorney Beatrice?
Yes.
Ms. Barger?
Yes.
Mr. Harge?
All right, before we go into executive session, is there anything else that anyone wants to bring up for us to consider prior to us meeting with our lawyer to get some legal advice on this? Okay, let's go into executive session. Executive session.
I will make a motion to come out of executive session.
Is there a second?
second,
Would the director call the roll?
Ms. Galpesta?
yes.
Attorney Beatrice?
Yes.
Ms. Barger?
Yes.
Mr. Harge?
Yes.
All right, just so the record is clear, anything that's been marked as an exhibit, I want to make sure the court reporter has it, and she affixes it to the transcripts that are going to be made in this case. I want to make some comments. First of all, I want to compliment both Mr. Uhasz and Mr. DeFabio. This was a very, very difficult decision for me. And we're just going to sort of out loud now say how we feel. I believe that we made an error in initially disqualifying Dom Leone, because I believe when we took those affidavits, the 5 affidavits, that put him at 50 and not 51. Now, assuming that Mr. Leone and Mr. Uhas are correct in that, well, we didn't have a chance to petition it, they did today. Clearly, there was no fraud. Clearly, there was no chicanery or anything like that, okay? I believe that when we took those affidavits, that he had 50 valid signatures. But if he didn't, certainly today, we allowed everyone a full opportunity to present it to us. I don't think that it's a second reconsideration. I just think that we are looking at this and trying to determine whether or not a candidate should be on the ballot. I don't believe that when we initially kicked him off that we should have done that. We took those affidavits, and even buying Mr. Uhas's arguments that we weren't correct in taking those affidavits, certainly today was an opportunity for us to correct any errors that we may have had. Everyone's had an opportunity to speak. We made a full and complete record, and if the court's going to decide to say, hey, what we did was wrong, then we'll take it. But certainly, everyone has had an opportunity to speak, to present evidence, and to make an argument. So it'd be my position that we put Dom Leone back on the ballot. That would be my position, and I'll let the other board members say how they feel, and then we'll take a vote.
I think the decision originally was made because of a signature, and we had testimony today from Richard Safko that definitely said that that was his signature. That puts him over the 50 signatures that are needed, and I believe we should put him back on the ballot.
I agree.
So how much is it?
I agree.
Because the
I do
last
think-
court decision, they criticized all the board members for not fully explaining their decision.
Well, I think the evidence brought before us today takes all notification of fraud away. There was no fraud in this case. I may say to the judge, though, it would have been better to get a few more signatures and not put us in this position, because it was very tough to go through these petitions and get them certified. So next time you run, if you do, just think about that. Have more time to get your petitions in order. But other than that, I think we have proven the case that, there's no fraud involved.
Mr. Arndt?
What we've done, what we've heard today is taken a very convoluted process that I think we made for ourselves in some respect. But I'm with Chairman Beatrice in thinking that Mr. Leone should be back on the ballot, since we heard from what we know now at this time.
So I need a board member to make a motion to put Dom Leone back on the ballot.
So moved.
Is there a second?
Second.
Any discussion? The only discussion I want to say is, to the extent that Mr. Malone complained that there was no process, there was plenty of process today. Plenty of process. And so if we did it wrong to start, we certainly are trying to remedy that. I don't think we necessarily did. We are tasking people to compare signatures, and I'll just say, I think these are lay people looking at a petition, trying to determine whether or not that's someone's signature. I could tell you, in the day, between morning and night, my signatures are vastly different. And depending on the circumstances, the stress and whatever, our staff tries to do the best they can. We've given everyone an opportunity to say, hey, this wasn't good. I hear Mr. Leon saying, well, you're giving them 2 considerations. Well, we considered your protest, and we allowed you to present evidence as to why we shouldn't do that. And so to the extent that Mr. Uas is correct, that maybe we shouldn't have taken those affidavits, but we did, we certainly cleaned that up today. So having said that, we will now have the director call the roll.
Ms. Calpesta?
Yes.
Attorney Beatrice?
Yes.
Ms. Barger?
Yes.
Mr. Orange?
Yes.
Now let's have a motion on the protest filed by Don Leon. Is there a motion to, what? I'm sorry, Malone and Leon.
Yeah.
Okay, and I'm old, so give me a break. And I just got over COVID, so, again. So I would now entertain a motion to rule on Mr. Malone's protest, either granting it or denying it. The chair will entertain a motion.
I motion we deny the protest because of the evidence heard today.
Okay, there's a motion made by Joyce Keel Pesta. Is there a second motion?
I'll second.
There is a motion made by Joyce Keel Pesta to deny the protest, seconded by Sandy Barger. Is there any discussion more than what we had? I'd ask the director to call the roll.
Ms. Calpesta?
Yes.
Attorney Beatrice?
Yes, meaning we deny the protest, correct? Yes.
Ms. Barger?
Yes.
Mr. Orange?
Yes.
Okay. So the result of our vote is that Mr. Leon is back on the ballot. I'm sorry. Yeah, Mr. Leon's back on the ballot. Mr. Malone's protest is denied. Now, do we have some things under new business?
We do.
Okay.
First, we have a letter from Henry Fine. He's does liquor auction. We have a liquor auction on the ballot in May in Jackson Township. I'd like to withdraw that and place it on the November ballot.
Now, so we don't run into this again, is he allowed to withdraw and refile the same petition?
Correct. Henry did a prosecutor's opinion on that, but we have one from Delaware County that just did that last week.
Okay,
So
so,
they're withdrawing the petition, the whole
No, they
thing?
just want to withdraw the language from the May and place it on November's.
all right, are they allowed to reuse those petitions?
Correct. Because they could have submitted those petitions now for November, prior to May.
Okay, all right.
And so we need a motion.
The chair will entertain a motion to withdraw the local option petition 5R questions 1 and 2 in Jackson Township.
So moved.
There's a motion made by Sandy Barger. Is there a second?
I'll second.
Seconded by Bob Arnott. Is there any discussion other than what we've already discussed? Will the director call the roll?
Ms. Calpesta?
Yes.
Attorney Beatrice?
Yes.
Ms. Barger?
Yes.
Mr. Orange?
Yes.
And our second new item is the Smith Township 2. There's a park levy on for the City of Alliance. We have 20 voters that sit in Smith 2 that can vote on this. In the past, we've asked Stark County to pick up those voters for us. It'll save us a little over $1,000.
We don't have any other voting out there other than this.
Nothing out there.
And the law allows us to kick this over to Stark County?
Yeah, there's a directive from the Secretary of State's office that allows that too, but we have to approve it first to the board, send it to Stark County, then Stark County will approve it next Monday. We talked with Stark County, they're going to do that in force. We'll have to notify those 20 voters in that precinct that the new location will be in Alliance City.
Okay. Is there a motion to take the 20 voters to vote on, is it a park levy?
It's a park levy.
A park levy over to Stark County.
So moved.
There's a motion made by Sandy Barger. Is there a second?
Second.
Seconded by Bob Arnott. Is there any discussion? I just want to point out, the last time this happened, how many people voted?
2.
2. So we spent $1,000 to have 2 people vote, or more than 1,000?
A little over 1,000.
Yeah, it's not being a good steward of the county's money, so we'll move that over. Would the director call the roll?
Ms. Calpesta,
Yes.
Attorney Petros.
Yes.
Ms. Barger.
Yes.
Mr. Orange.
Is there anything else on the new business?
I'll make a motion, we adjourn.
There is a motion, when's our next meeting?
April 4th.
Let's just everyone double check their calendars. April 4th.
Do you want to do public comments?
Oh, are there any public comments? I'm sorry. None? Okay, the next meeting is set for April the 4th at 4 p.m.
Is that what it is?
We've been setting them all at 4. Would the director call the roll on the vote, on the motion to adjourn?
I'll second the motion.
Second.
Ms. Calpesta.
Yes.
Attorney Petros.
Yes.
Ms. Barger.
Yes.
Mr. Orange.
Yeah.
Thank you, everyone.